Your Excellencies, distinguished guests, ladies and gentlemen, good morning. My name is Hemi Kim, and I am a conference interpreter. And today I have the honor and pleasure of serving as your MC for the 13th Asia-Pacific ADR conference titled ADR Reborn, Dynamics of Renewed Asian ADR Landscape. This conference is organized by KCAB International and is co-hosted by UNCITRAL, the Ministry of Justice of Korea, and the ICC. On behalf of our hosts, I would like to express my heartfelt welcome and gratitude to all of our esteemed guests who are gracing the occasion with their presence today. Thank you so much for joining us today, both online and offline, and welcome to Seoul. In particular, we would like to thank our honored guests who have traveled long distances to be with us here today on site. So, without further ado, let us begin the 13th Asia-Pacific ADR Conference. First of all, it is my great joy and privilege to introduce His Excellency, Mr. Seung Park, the Minister of Justice of Korea, who will deliver his opening remarks to officially commence the 13th Asia-Pacific ADR Conference. 박성재 법무부 장관님께서 개회사를 좀 들려주시겠습니다. 장관님 앞으로 모시겠습니다. 여러분 큰 박수로 환영해 주십시오.
안녕하십니까. 대한민국 법무부 장관 박성재입니다. 오늘 귀중한 시간을 내어 제13회 아시아 태평양 ADR 컨퍼런스에 참석해 주신 모든 국내외 귀빈 여러분을 진심으로 환영합니다. 먼저 이번 행사의 성공적인 개최를 위해 함께 애써주신 UNCITRAL과 대한상사중재원 그리고 ICC 관계자분들께 감사드립니다. 또한 바쁘신 가운데에서도 기꺼이 발제와 토론을 맡아주신 전문가 여러분께도 진심으로 감사드립니다. 아시아 태평양 지역이 세계 경제에서 차지하는 비중은 날로 커지고 있습니다. 포춘지가 선정하는 세계 500대 기업 중 아시아 기업의 비중은 무려 46%에 이른다고 합니다. 그러나 ADR 분야에서 아시아의 역할은 경제적 비중에 미치지 못한다는 것이 냉정한 평가이자 현실이며 명망 있는 ADR 관련 기구의 대부분이 영미법계 국가에 소재하고 있다는 사실이 이를 방증하고 있습니다. 아시아 이용자들에게는 그들만의 수요가 있습니다. 예를 들면 아시아 국가 중 상당수는 대륙법계 국가이고 대립보다는 화합을 선호하는 고유의 문화적 감수성이 있습니다. 아시아 ADR의 발전을 위해서는 ADR의 세계적 흐름뿐만 아니라 아시아 산업 생태계의 ADR 수요에 대한 세심한 배려가 필요한 것입니다. 따라서 이번 컨퍼런스에서 변화하는 아시아 ADR 환경의 역동성을 주제로 아시아 ADR의 발전 방향을 논의하는 것은 매우 시적절하다고 생각됩니다. 아시아의 ADR이 경제적 위상에 걸맞도록 재탄생하기 위해서 오늘 이 자리에 모인 우리가 힘을 모아 아시아 이용자들의 다양한 수요를 충족시켜줄 창의적이고 유연한 모델을 제시할 수 있기를 진심으로 희망합니다. 대한민국 법무부도 다양한 방법으로 아시아 ADR 산업의 발전 노력에 동참하고 있습니다. 법무부는 중재산업진흥에 관한 법률에 따라 대한민국이 국제적인 분쟁 해결의 중심지로 거듭날 수 있도록 재정 지원 및 제도 개선에 최선을 다하고 있습니다. 또한 국내외 ADR의 활성화, ISDS 예방 및 대응체계 일원화 등을 목표로 2023년 8월 국제법무국을 신설함으로써 국제법무 역량을 크게 강화하였고 조정에 의한 국제 화해 합의에 집행력을 부여하는 싱가포르 조정협약의 이행법률 입법을 추진 중에 있습니다. 캄보디아 정부의 조정 법제 정비 제도 사업에도 인적, 물적 지원을 아끼지 않고 있습니다. 현대 경영학의 창시자인 피트 드러커는 미래를 예측하는 가장 훌륭한 방법은 미래를 만들어가는 것이라고 하였습니다. 대체적 분쟁 해결 분야의 미래와 그 속에서 아시아 태평양 지역의 역할을 정확하게 예측하기는 어렵습니다. 그렇다면 우리가 먼저 이런 컨퍼런스를 통해 이용자 친화적인 아시아 ADR 모델을 제안하고 이러한 모델이 구체적인 분야에서 어떻게 활용될 수 있는지 선명하게 제시함으로써 아시아 ADR의 미래를 만들어 나가야 할 것입니다. 대한민국 법무부도 아시아 태평양 지역과 대한민국이 함께 대체적 분쟁 해결 분야의 중심지가 될 수 있도록 최선을 다하겠습니다. 다시 한번 오늘 참석해 주신 여러분들을 진심으로 환영하고 모든 분들의 건강과 행복을 기원합니다. 경청해 주셔서 감사합니다.
His Excellency Mr. Seung Park, the Minister of Justice of Korea, has just delivered an exceptional opening speech. Thank you for your participation in the 13th Asia-Pacific ADR Conference despite your very busy schedule. Thank you very much, Minister Park. 바쁘신 일정에도 불구하고 오늘 친히 자리를 빛내주신 박성재 법무부 장관님께 진심으로 감사의 말씀 드립니다. Next, I am very pleased to introduce the Honorable Professor Seung Chang, Chairman of KCAB International, who will deliver his welcome remarks. Professor Chang, please come forward. Ladies and gentlemen, please welcome him with a big round of applause.
Distinguished guests, Honorable Mr. Minister Park, friends and colleagues. It's my great pleasure to welcome you to the 13th Asia-Pacific ADR Conference, which is the main event for the Seoul Arbitration Festival. As the new chairman of KCAB International, I would like to first express my gratitude to our co-host, the Ministry of Justice of Korea, UNCITRAL and ICC for their continuous support for the KCAB International and this event over the past 13 years. This year marks a new beginning for the Seoul ADR Festival. For the past 12 years, this event has provided a great platform for ADR experts and users to share ideas, opinions, and sometimes constructive criticism to enhance our ADR services. This year, we have shifted our focus of the event to listen more carefully to the voice of Asian ADR service users. As pointed out by Minister Park, the growth potential of the Asia ADR market is evident, and I believe the Seoul ADR Festival serves as a great platform through which ADR service providers can pay more attention to the needs of the Asian ADR service users under different legal tradition and corporate cultures. KCAB International is now embarking on a new journey. We are currently in the process of reforming the governing structure to provide more transparent and high-quality case management process. Under our forthcoming new rules, we attempt to be reborn as one of the leading arbitral institutions under the civil law jurisdiction in Asia. In addition, from next year, KCAB International will reach out to our fellow Asian institutions, in particular, the ones at the development stage, to further discuss how we can promote and expand the Asian ADR arena in a mutually beneficial manner. I already received some warm response from other Asian jurisdiction, and I also confirm with a UNCITRAL that UNCITRAL will work closely with our institution to pursue this goal. I hope all of you will enjoy and actively participate in today's conference as we have prepared this program enabling us to be interactive with all the participants, even from the floor. Once again, thank you very much and enjoy the Seoul ADR Festival.
Thank you, Professor Seung Chang, Chairman of the KCAB International, for your outstanding welcome remarks for the 13th Asia-Pacific ADR Conference. Next, it is my great honor and pleasure to introduce the Honorable Madam Anna Joubin-Bret, Secretary of UNCITRAL, who will deliver her congratulatory remarks to celebrate the commencement of the 13th Asia-Pacific ADR Conference. Ladies and gentlemen, please welcome Madam Secretary with a big round of applause.
The Honorable Seung Park, Minister of Justice of the Republic of Korea, Professor Seung Chang, Chair of KCAB International, Excellencies, distinguished speakers, guests, and friends of UNCITRAL. I'm most honored to deliver these congratulatory remarks for the 13th Asia-Pacific ADR Conference. The tremendous interest in this year's iteration, with so many of you coming from close by but also afar, is testament to the pivotal and ever-growing role that Korea and the Asia-Pacific region have in global dispute resolution community, befitting of this year's theme, ADR Reborn, Dynamics of Renewed Asian ADR Landscape. I'm pleased to have witnessed this continuous success firsthand, having attended this conference every year since its inception. And I'm delighted that this year's conference showcases many issues at the forefront of UNCITRAL's agenda, including on technology-related dispute resolution and on investor-to-state dispute settlement. With the advent of the digital economy, we witness an important shift in the focus of the topics for international lawmaking, including in relation to dispute settlement. Please allow me to take this opportunity to highlight two relevant developments from the Commission this July: the work carried out by UNCITRAL Working Group 2 on technology-related dispute resolution and adjudication, and the upcoming work on electronic arbitral awards and electronic notices. Regarding the legislative work on technology-related dispute resolution and adjudication, the Commission adopted the UNCITRAL model clauses on specialized express dispute resolution, which offer customized solutions for parties in disputes, with model clauses on highly expedited arbitration, so even faster than fast, adjudication, technical advisors for the tribunal, and confidentiality. This July, the Commission also mandated UNCITRAL to work on the recognition and enforcement of electronic arbitral awards and electronic notices. Narrowing down these issues, the Working Group 2 recently held a colloquium on the recognition and enforcement of electronic arbitral awards, with experts from different regions and legal systems contributing to the practice and also the risks and benefits for dispute resolution. Let's just pause a second and think and bring back dispute resolution, commercial dispute resolution, to the broader context where it operates, namely as an accessory to international trade, as the dispute resolution mechanism to digital trade. With trade going digital as we see it now, it's only normal that the dispute resolution mechanisms also embrace the new technologies and embrace the digital format for delivering as fastly and as efficiently as traders nowadays expect. So this is what UNCITRAL will be looking at more carefully and in more detail in the coming months and the coming year, hopefully. So please stay tuned to that. A last update, if I'm allowed, is the adoption in principle by the Commission of the statute of an advisory center on international investment dispute resolution as one of the elements of the investor-state dispute settlement reform that UNCITRAL has been mandated to carry out. Once established, this advisory center will provide training, support, legal representation, and assistance with regard to international investment dispute resolution, and enhance the capacity of states, particularly least developed and developing countries, in preventing and handling investment disputes. Since the establishment of the Advisory Center on International Investment Dispute Resolution will require further preparatory work, the Commission has initiated an informal process to tackle core issues such as the location of this center and its link with the UN system in order to advance it and make sure that the advisory center can actively take part in the delivering of the reform. The UNCITRAL Secretariat remains committed to finding global solutions to further advance these issues, and we count very much on the support of contributors, including stakeholders in Korea, in the Asia-Pacific region and beyond. So thank you very much again to the Korean Ministry of Justice, to KCAB International, to the ICC Dispute Resolution Services for this opportunity to engage and to share with all of you. I wish all participants the most successful conference. Thank you very much.
Thank you very much, Madam Secretary. We would like to express our heartfelt appreciation once again. So far, we have heard from 3 distinguished speakers, and of course, we also have an insightful keynote speech in store for you. But first, please give us a few minutes and remain seated while we rearrange our stage for our next session. If you're joining us online today, please stay tuned. We'll be right back. Thank you so much for your understanding once again. Now it's time for our keynote speech, which will be delivered by the Honorable Mr. Gary Bourne, and his keynote speech is titled Recent Developments in International Arbitration. To give you a brief introduction of our distinguished keynote speaker, Mr. Gary Bourne is chair of the International Arbitration Practice Group at Wilmore Cutler Pickering Hale and Dorr LLP, and he is the world's preeminent authority on international commercial arbitration and litigation. And finally, we are ready to listen to the long-awaited keynote speech titled Recent Developments in International Arbitration, which will be delivered by the Honorable Mr. Gary Bourne. Ladies and gentlemen, please welcome him with a warm round of applause.
Distinguished guests, I'd like to start, of course, by thanking the Ministry of Justice, UNCITRAL, the ICC. I'm allowed to thank them now that I've changed my role. And of course, most importantly, perhaps, KCAB. Even more importantly, though, I'd like to thank all of you. As usual, it's a beautiful day here in Seoul. Sun is shining, the temperature's perfect. There are many things you could be doing on this glorious morning apart from listening to me, and I very much appreciate each one of you taking your time, your busy time to listen to me. I am supposed to give a keynote speech here at the ADR Reborn conference. I'm not sure quite how they came up with either that name or the invitation to me. Perhaps a coincidence, perhaps not. But instead of giving you a keynote speech, I thought I would do something else. Keynote speeches are supposed to be broad, full of grand ideas to get us all thinking about lofty ideals and goals. I think actually I'm going to give a different kind of speech. I'm going to give a keyhole speech instead of a keynote speech. And it is a little bit based on modern culture, what we learned, no doubt, in COVID or perhaps before then, about applications, apps, and the way that they can mold our future. What I thought I would do would be look at recent developments and using the modality of the apps that if we don't use, we're all familiar with, swiping left if we don't want something to be in our future, and swiping right if we approve of it and in fact want it to be in our future. Part of my keyhole speech will therefore be not just describing recent developments, but by giving an opinion on it, correct or incorrect, provocative or boring, but nonetheless a clear opinion. I'll either swipe right or swipe left. And what we'll do is just take a quick journey around the world, starting looking at recent developments in international arbitration, starting here in Asia with a decision that you may or may not be familiar with, and in global mercantile. It was a case that involved that profoundly interesting question of the validity of an arbitration clause where the underlying main contract was itself challenged and indeed void. It was void under Indian law, it was said, because the underlying contract in which the arbitration clause was contained wasn't properly stamped, and absent proper stamping, that contract was void. The question, therefore, was whether the arbitration clause contained in that contract itself was also void. It wasn't stamped either. A three-judge panel of the Indian Supreme Court rejected that argument, held that the arbitration clause was a separable, autonomous agreement, that the unstamped character of the underlying contract didn't vitiate the separate autonomous arbitration clause, and therefore the parties could be required to arbitrate. Swipe right. That recognition of the principle of separability of the arbitration clause enshrined in the UNCITRAL model law in Articles 7, 8, and 16 is well recognized. We like what the Indian Supreme Court, the three-judge panel, did in NN Global. However, shortly thereafter, a five-judge panel of the Indian Supreme Court reached the opposite conclusion. The arbitration clause contained in the contract, which was null and void because it wasn't stamped, couldn't itself, as part of that contract, be valid. It refused to require the parties to arbitrate. Swipe left. That ignores the long-standing principle of separability. The good news is, shortly thereafter, a seven-judge panel of the Indian Supreme Court went back to where we began, not with Article 16 of the model law, but with what the three-judge panel of the Indian Supreme Court concluded, namely that the arbitration clause was separable, not vitiated by the unstamped and therefore invalid character of the underlying contract. Swipe right. We like that in our future. But let's pause for a moment and think. The arbitration clause is a separable contract. Indian law required that contracts be stamped. Why isn't it, even as a separable contract, void and invalid? Why isn't the separability doctrine not enough to get us to a valid arbitration clause? I'm not qualified to practice in India, nor, to be honest, in most other places. But at least in international cases, I think there is a good answer to the question I pose. Why, in an international contract, was the separable arbitration clause valid? It was valid because the New York Convention contains a mandatory form requirement, both a minimum and a maximum requirement. It doesn't require that arbitration agreements be stamped, only that they be signed. And therefore, at least in an international context, the Indian Supreme Court seven-judge bench reached the proper conclusion, as I said, swipe right. Let's move to another common law jurisdiction. This is the United Kingdom. It addressed, in a case called Enka versus Chubb, and then subsequently another case called KCAB, the perennial question of what law governs an international arbitration agreement. The perennial dispute, of course, is between the law the parties choose to govern their underlying contract, most international contracts having choice of law provisions, and, on the other hand, the law of the arbitral seat, assuming that these are in two different jurisdictions. The KCAB case involved a contract in which the parties had chosen that their agreement, their contract, be governed by English law, but seated their arbitration in France, in Paris. The UK Supreme Court concluded in those circumstances that the parties' choice of law clause in their underlying contract applied to the arbitration agreement, and hence, notwithstanding an arbitration seated in Paris, English law, according to the UK Supreme Court, governed the arbitration agreement. Swipe left. That's wrong. The arbitration agreement bears a much closer connection to the arbitral seat than to the law chosen by the parties to govern their underlying contract. The arbitration agreement, as we just learned from the Indian Supreme Court seven-judge bench, is a separable contract, not governed by the choice of law clause in the underlying contract. The French Court of Cassation considered exactly the same issue in that case. It concluded that the arbitration agreement providing for arbitration seated in Paris was governed by French law by virtue of the suite. Swipe right, for the reasons I explained already, that is the correct view. Let's go back to England. The UK Law Commission's review of the English Arbitration Act addressed the issue which the UK Supreme Court addressed in KCAB and Anka versus Chubb. You can see its recommendation on the slide. It rejected the UK Supreme Court's view. It concluded that it should recommend, as it did, that absent a clear and specific choice of law governing the arbitration agreement itself, as distinguished from the underlying contract, the arbitration agreement would be governed by the law of the seat of the arbitration. Swipe right, just like we swiped for the French Cour de Cassation. That reached the correct result. The UK Supreme Court, however, in Unicredit, Bank versus Ruschem Alliance, persisted, presented with arguments that it ought to have regard to the Law Commission's recommendation. The UK Supreme Court doubled down on its previous holding that an arbitration agreement is governed by the law selected by the parties to govern their underlying contract. Swipe left for all the reasons that I already explained. But there's good news at the end of this English tunnel. The good news is that pending in the UK Parliament and expected to pass hopefully by the end of the year or early next year is exactly what the UK Law Commission recommended, namely that the result in KCAB and Anka versus Chubb be reversed and that arbitration agreements be presumptively governed by the law of the arbitral seat. Swipe right for that result. Continuing with our exploration of international arbitration agreements, a fascinating set of issues arising from recent developments in the Middle East. Baker Hughes versus Dynamic Industries. You can see it on the slide. Dubai, part of the UAE, organized a quite successful international arbitral center, the so-called DIFC-LCIA, a joint venture of sorts between the LCIA and the Dubai International Financial Center, an arbitral institution much favored by users in the region and indeed those from elsewhere. Numerous contracts contained, therefore, DIFC-LCIA arbitration clauses. The ruler of Dubai, however, last year saw fit to shutter the DIFC-LCIA and, by edict, by decree, to replace it with a pre-existing institution, the Dubai International Arbitration Center, DIAC. All of the functions of the DIFC-LCIA were, by government decree, transferred to the Dubai International Arbitration Center. And that presented, unsurprisingly, the question, what happens to all those arbitration agreements providing for DIFC-LCIA arbitration? That was the issue presented in Baker Hughes. One party, the Middle Eastern party, sought against a US party, Baker Hughes, to require arbitration in DIAC, pursuant to the governmental edict. Baker Hughes took a different view. It sued in Louisiana. I doubt the arbitration was seated in Louisiana. I suspect Baker Hughes sued in Louisiana because it thought it a favorable forum. And unsurprisingly, the Middle Eastern party sought to have the litigation referred to arbitration pursuant to the rules of the DIAC. The Louisiana District Court, on the slide, rejected that argument, saying that the parties had never agreed to DIAC arbitration, that their DIFC-LCIA arbitration agreement was invalid because there, unsurprisingly, was no DIFC-LCIA anymore. And therefore, it permitted the litigation to go forward. What do we think about that? Swipe left or swipe right? I'll say what immediately springs into your minds, which is swipe right. The parties didn't agree to DIAC arbitration. In fact, they chose something else. If you're wondering whether that's correct or not, we can see what the Singaporean courts in a case called DFL versus DFM said. And although the decision ultimately rested on other grounds, the court, relying on a doctrine of impossibility, you can't arbitrate anymore in front of an institution that doesn't exist, indicated that it would have held that the arbitration agreement was invalid. Swipe left or swipe right? If you swiped right before, you'd swipe right again. One more case in this little journey. Narciso versus Nash. This one not by a court outside the UAE, but instead one inside the UAE, indeed inside the Dubai International Financial Center, where that court concluded that the government edict transferring the functions of DIFC-LCIA to the DIAC was in fact valid, and the parties would be both permitted and required to arbitrate under DIAC rules. Swipe right or swipe left? If you swiped right before, then it's time on this one to swipe left. And to some extent, one could understand why that's the case. Of course, the parties had not chosen DIAC arbitration, and the fundamental foundation for international arbitration is that of consent. They hadn't consented to DIAC arbitration. They'd consented to something else, and it was the government now that was directing them to DIAC arbitration. That can't be right. Or is it? Is this issue perhaps a little more complicated than what all of the courts and perhaps we initially had thought? The parties did agree to arbitrate. Nobody would dispute that. And the shuttering of the DIFC-LCIA arbitration institution therefore needs to be excised from the arbitration agreement. You can't perform that term of it anymore, as the Singapore court correctly concluded. But that doesn't mean that the parties haven't, in fact, agreed to arbitrate. They still have, one might say, an agreement to arbitrate. And the question is, what actually does that arbitration agreement say? And I would suggest that, and this is a little more complicated than apps where you can only swipe right and swipe left, I would suggest that one needs to look to where the arbitral seat is. If the parties agreed to arbitrate with a seat in Dubai, and you then have a gap in their contract, their arbitration agreement, because the DIFC-LCIA has gone away, then that gap needs to be filled. The obvious thing to fill it with is the laws of Dubai, which, as we saw, provide that the functions of the DIFC-LCIA will be assumed by DIAC. Is that a bad result? Think a little bit about what the world would look like if you didn't adopt that result. One might well conclude in those circumstances that you had an agreement to arbitrate ad hoc in Dubai, meaning that the appointing authority would be the Dubai onshore courts, probably the thing that Baker Hughes and the other international parties would most have wanted to avoid, and that the gap-filling provision of the Dubai edict actually puts them in a not bad situation. Conversely, if the seat is outside of Dubai, then it's much less clear that the Dubai edict really says very much at all about how you fill gaps in the arbitration clause, and an ad hoc arbitration seated in a jurisdiction outside of Dubai might be something very much within the parties' contemplation. I'm a little bit biased about this particular view, but swipe right for it. It's the proper conclusion. Let's look very quickly at one more set of recent developments, the rise of regional arbitration centers. I know the ICC is one of our sponsors, but the world has grown much more complex over the last 50 years. The ICC was the predominant arbitral institution 50 years ago. Today, whether in Asia with SIEC, HKSC, KCAB, and others, or in Latin America with CAM, CCBC, and other arbitral institutions, or in the Middle East with some of those institutions I just described. Arbitral institutions that sometimes are called regional, sometimes have global aspirations, have significantly increased their share of international arbitrations. And that's a good thing. It creates more diversity, more options for users. This is a slightly different take on developments over recent decades. It looks at the top 10 seats in ICC arbitrations, a little bit Eurocentric, but the ICC remains, despite the rise of regional institutions, the world's preeminent arbitral institution. And its figures are, to some extent, representative, notwithstanding their Eurocentricity. They show the selection by parties and by the ICC of arbitral seats. It's a little bit hard to see what is on the slide because of the size. Let me summarize it for you, though. What it shows is that Switzerland, followed by France, have remained the most significant in terms of numbers, choices of seats by parties in ICC arbitrations. But it also shows, very importantly, that their numbers have remained essentially flat. Their numbers haven't increased significantly over time. At the same time, as we all know, that the ICC's caseload has very significantly increased. Put differently, their share of ICC arbitrations has reduced, and the margin has been assumed by other arbitral seats, including, in particular, places like Singapore, Brazil, the UAE, and I have no doubt, Korea. And that, again, is a good thing. The rise of arbitral seats outside of the ICC's traditional favorites is a good thing for users. Having just said some nice things about Singapore, let me change tack. This is a decision involving either the annulment or non-recognition of arbitral awards. We'll shift gears slightly from my obsession with arbitration agreements and talk about arbitral awards. The issue in this case was whether an arbitral award could be denied recognition or alternatively annulled on the basis that either the arbitral tribunal or the arbitrators did not comply with the parties' agreed arbitral procedures. For those of you fanatic about the New York Convention like me, there's Article 5, 1D, and Article 34, 2A, 4 of the UNCITRAL model law. One of the bases for setting aside or denying recognition of an award is that the procedures that the parties agreed to with respect to the arbitration weren't followed. And what I'd like to do, using first the Santam Investments case, but then a couple other decisions, is explore exactly how those provisions are best applied in practice. When the parties have agreed very clearly to what the procedures are, it makes perfect sense. If they agree to an arbitration in Korean, seated in Seoul, Korea, under KCAB rules, and the arbitral tribunal instead conducts the arbitration in English, substitutes the ICC rules for the KCAB rules, and says the arbitration is really seated in, say, New York, that would be very good grounds for denying recognition of the award or alternatively annulling it. Parties often, though, are not so clear in their agreements. Indeed, parties very frequently are ambiguous or confused or contradictory with respect to their procedures. And that was exactly what happened in Sanam Investments. There, the parties had, in their drafting wisdom, agreed that the arbitration would be conducted by a well-known arbitral institution in Macau. And that's all they said. Everybody who looked at that clause, and I'm sure all of you would agree that that is among the most poorly drafted arbitration clauses that one can imagine. Does it pick a seat or doesn't it? It's not really very clear. Does it pick an arbitral institution? I guess you'd go look at what arbitral institutions there are in Macau. But as the Singapore Court of Appeal acknowledged, this was a profoundly ambiguous clause. The claimant in the case commenced an arbitration under the Singapore International Arbitration Center rules, concluding that it was the best-known arbitral institution in Macau. I can't vouch for that, but it sounds correct to me. The Singapore International Arbitration Center appointed an arbitral tribunal who looked at the parties' agreement and concluded that, yes, indeed, the parties had agreed upon the SIC rules, and by virtue of that agreement, they'd also at least impliedly agreed or perhaps authorized the arbitral tribunal to select the arbitral seat in Singapore, which the tribunal did. The respondent defaulted in the case, so it didn't say much about all of these various issues. The arbitral tribunal, after long and expensive proceedings, made a hefty award for the claimant. And when the award was sought to be confirmed in Singapore, the Singapore courts refused to confirm the award. They held, effectively, that the arbitral tribunal, the arbitral institution, hadn't complied with the parties' agreed procedures because, in its wisdom, the Singapore Court of Appeal concluded that what the parties really meant when they had that ambiguous arbitration clause was an arbitration seated in Macau. And the arbitration hadn't been seated in Macau, it had been seated in Singapore. And a fundamental mistake of that nature was a basis for setting aside the award. Swipe left very hard. That's the wrong approach. Where you have a truly ambiguous arbitration agreement, modesty is required. Modesty on the part of courts in annulment and recognition proceedings. Deference to what an arbitral institution whose entire point in life is to figure out these ambiguous arbitration clauses and make sense of them, and arbitral institutions and arbitral tribunals, whose job also it is to interpret those sorts of provisions. And if at the end of the day, the court thinks in a case of that ambiguity, the arbitral tribunal got it wrong, it ought instead hold its hand and defer to what those who had to conduct the arbitration concluded. And that's particularly true both because of the expertise of those institutions and those tribunals, but perhaps more importantly because at the end of the day, none of us will really know what that arbitration clause meant. Did it mean an arbitration seated in Macau? Did it mean an arbitration seated in Singapore? Or did it mean to leave the choice to the arbitral tribunal? There isn't, in some very real sense, any right answer to that question. And deferring to the arbitral institution and the arbitral tribunal is the proper course. A similar mistake was made by the Shanghai Court of Appeal in a case called Noble Resources versus Shintai. I'm going to switch back to being faithful to Singapore for this one. There, the Singapore International Arbitral Center applied its expedited procedure rules, which, as I'm sure you know, provide that in certain small value cases, less than $5 million or so, the institution can, at the request of one of the parties, apply its expedited procedures, which mean that the arbitration will be conducted in less than 6 months by a sole arbitrator with the possibility of documents-only arbitration as opposed to a live hearing, and a summary award. Users love this, businesses do, because it saves time and money. The issue in Noble Resources, which involved an effort to recognize an award made pursuant to those expedited procedures, was whether the award could be denied recognition under our old friend Article 5.1d on the basis that an arbitration conducted pursuant to expedited procedures didn't comply with the parties' arbitration agreement. Why didn't it comply with the parties' arbitration agreement? It didn't, it was said, because the parties' arbitration agreement provided there shall be 3 arbitrators. And in an expedited procedure, there was only 1 arbitrator. The Singapore courts and the Singapore International Arbitration Center, in a case involving, like this case, Noble Resources, a Singapore-seated arbitration, had addressed exactly that issue on multiple occasions. And they had concluded that when you had conflicting provisions of this nature, a choice of 3 arbitrators on the one hand, an expedited procedure mechanism for small value cases on the other hand, you needed to reconcile those 2 provisions. And it could be done. The way you reconciled them was saying your choice of 3 arbitrators applies to all arbitrations except small value expedited procedure cases. By agreeing to the SIEC rules, you agreed to the possibility in small value cases of a sole arbitrator, which is part of the expedited procedure mechanisms. Again, there is some ambiguity between those different provisions. One could fairly, I would suggest, arrive at different interpretations of how one reconciles or chooses not to reconcile them. But the proper role of a recognition court, I would suggest, also of an annulment court, but a proper role of a recognition court would not be to prefer its own view of the situation, but instead, again, exercise modesty, to defer to the choice both of the arbitral institution as to how to interpret and apply its rules on the one hand, but also in this case, the courts of the arbitral seat who had upheld exactly that interpretation. Swipe left for Noble Resources. But in a similar case, Bamberger versus Rosenheim, a US court addressed essentially the same issue, the question of to what extent does an annulment court defer to the decisions of an arbitral tribunal on issues of procedure. We'll swipe right on Bamberger, but let me tell you what it involved. Bamberger involved one of those cleverly drafted arbitration clauses that provided that the arbitral seat shall be in the hometown of the respondent. And as a consequence, whichever party commences the arbitration has to commence an arbitration seated in its counterparty's home jurisdiction. Parties seem to like this sort of provision because they believe that it provides a disincentive to commencing claims. As inevitably fate would have it, the claimant commenced an arbitration in the respondent's hometown, and the respondent counterclaimed, of course, in that same arbitration. The arbitral tribunal considered the argument that actually the respondent wasn't allowed to counterclaim because it had to start an arbitration in the claimant's hometown if the respondent wanted to pursue claims. The arbitral tribunal rejected that argument. The arbitral tribunal concluded that, in fact, you can bring counterclaims in an arbitration, including in your own hometown. That's a fair interpretation of the parties' agreement, although, to be honest, at the end of the day, how would you ever really figure out what those parties intended with respect to counterclaims? There's probably no right answer to that particular question either. And that was what the Court of Appeals in Bamberger ultimately concluded. We won't try to second guess how an arbitral tribunal interprets an ambiguous provision of this character. And I would suggest that that is the correct result. Swipe right. And now, finally, in the minute remaining for recent developments, a series of recent developments involving the independence and impartiality of arbitrators. Let's begin with the Gaillard eulogy. The tragic and early demise of Emmanuel Gaillard led to eulogies, including by a gentleman who was an arbitrator in a case involving Professor Gaillard's firm. The tribunal issued an award which was challenged on the basis that the eulogy written by the chairman of the arbitral tribunal for Professor Gaillard revealed his undue sympathies for Professor Gaillard and therefore, by extension, his firm. This is one of the rare cases where an arbitrator's public comments, by way of a commentary, for example, or something like that, are held to impeach his or her impartiality, but probably swipe right. Tribunals need to maintain the confidence of the parties, and even in the unique circumstances of a eulogy, that impartiality has to be unchallenged. Very quickly, because time has almost expired, Halliburton versus Chubb, the UK Supreme Court, notwithstanding any statutory basis, upholding the obligation of arbitrators to disclose circumstances that might lead a reasonable observer to question their impartiality and independence. The UK Law Commission reaching pretty much the same result in a recommendation, giving effect to that UK Supreme Court holding and recommending a statutory amendment that would, as in the UNCITRAL model law and otherwise, require disclosures and continuing disclosures by arbitrators. The recent light touch revisions to the IBA guidelines also accomplishing the same result. And finally, the last recent development before I leave you, a suggestion that we might have gone a little bit too far with the IBA guidelines and things like them. I don't have time to show you statistics on this, but following the IBA's publication of its guidelines in the turn of the century or so, the number of challenges in ICC and other arbitrations, institutional arbitrations, very significantly increased, notwithstanding the fact that the number of successful challenges didn't move hardly at all. One might think, who really cares? No harm, no foul, just because there are more challenges, even if unsuccessful ones, doesn't really mean that anything bad has happened. I would suggest that's not true. The delays and costs that challenges impose on the arbitral process, the use of those challenges as guerrilla tactics imposes a very real cost on something that promises its users that it will be cheaper and more efficient than other means of dispute resolution. And, as this final case illustrates, Grupo Unidas versus the Panama Canal Authority, those very issues can arise in annulment proceedings. There, an ICC tribunal made a significant award, following which the losing party did what losing parties often did, namely scour Google for potential conflicts, and challenged then the arbitrators under the ICC rules on the basis that they had failed to disclose that they were sitting together, various of them in different constellations in other cases. The ICC considered that challenge. It rejected it. It refused to remove the arbitrators. But in the course of its very long decision, ruling on those challenges, it also said that disclosure should have been made, which provided exactly the jumping off point for an effort to annul the award that those arbitrators had made on the basis, under our old friend, Article 5.1d, of a failure to comply with the parties' agreed arbitral procedures. The argument was fairly straightforward and, in a sense, predictable. The parties agreed to arbitrate under the ICC rules. Those rules required disclosure. The arbitrators didn't make the disclosures, and the fact that the ICC didn't remove those arbitrators subsequently doesn't change the fact that the arbitration wasn't conducted pursuant to the rules in compliance with the rules that the parties agreed. Fortunately, I would suggest, the Court of Appeals in the United States rejected that argument. It said that one needed to show something much more significant than a non-disclosure, particularly a non-disclosure that didn't result in removal of the arbitrators in question, in order to take the dramatic step of annulling an award. Swipe right for that one. And with that, we have finished our review with editorial comments of recent developments in international arbitration. Thank you very much.
The Honorable Mr. Gary Bourne has delivered a keynote speech titled Recent Developments in International Arbitration. Thank you very much, Mr. Bourne, and we would like to extend our sincere gratitude once again to Mr. Bourne. We will conclude the opening ceremony of the 13th Asia-Pacific ADR Conference. We would like to express our sincere gratitude to all of our speakers. We will now take a short 10-minute break before our first session of the day. So now please enjoy your break.